Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update from the Supreme Court, which today delivered its judgment in the PIL petition, which sought to formulate a community kitchen policy to avoid starvation deaths in India. Similar to the concept of soup kitchens in the US and Europe, the petitioners here sought a policy to feed the poor by serving a limited menu of nutritious cooked food at below the market price. The objective was to combat hunger and malnutrition. As per the verdict, the bench of Justices Bela M. Trivedi and Pankaj Mittal has left it open to the states and the union territories to explore this option as a means to achieve the objectives of the National Food Security Act of 2013. The bench declined to pass directions to formulate a pan-India community kitchen policy, given the fact that the National Food Security Act was in force and various welfare schemes under the said act have been framed by the union and states to provide food and nutritional security to people at affordable rates. The court did not assess if community kitchens were a better option for National Food Security Act goals. The matter is left to the states and union territories' decision. Accordingly, the PIL seeking the formulation of a community kitchen policy was disposed of. In a significant update to India's surrogacy regulations, the central government has revised the Surrogacy Regulation Rules of 2022. Previously, according to the 2023 amendment, Form 2 of the Surrogacy Rules, read with Rule 7, prohibited couples from using someone else's eggs if they wanted to have a baby through surrogacy. The same has now been amended by a notification of the Ministry of Health and Family Welfare. Surrogacy using donor gamete shall now be permissible if the district medical board certifies that the husband or the wife constituting the intending couple suffers from a medical condition that necessitates use of a donor gamete. This is still, however, subject to the condition that at least one gamete shall come from the intending couple. I must tell you, last year, the 2023 amendment was challenged before various courts. A woman suffering from MRKH syndrome had challenged the same before the Supreme Court. Her condition prevented her from producing eggs. In course of the hearing, it was observed by the top court that the insistence on the egg and sperm of the intending couple for gestational surrogacy was prima facie against Rule 14A of the Surrogacy Rules. Eventually, the top court had allowed the use of donor egg for surrogacy by staying the application of the amendment in this case, while leaving the larger issue open for consideration. To read in detail about this, you can visit livelaw.in. The next update is regarding the controversy over the name of a lioness at Siliguri's Safari Park. As we have reported earlier, a plea by the Vishwa Hindu Parishad against the naming of lioness as Sita has been filed. A bench of Justice Saugata Bhattacharya continued to hear the matter today. The Additional Advocate General told the bench that the naming of the lions occurred in Tripura and therefore it falls under the responsibility of the Tripura Zoo authorities. The counsel argued that the writ petition filed by VHP was not maintainable because it does not involve any personal rights of the petitioners. Additionally, he said that the state itself was considering the option of renaming the lions. Upon hearing these arguments, the bench directed for reclassification of the plea as a PIL and for it to be placed before the regular bench having determination over PILs. The court also expressed that animals could not be named after revered figures like mythological heroes, freedom fighters, or Nobel laureates. The release of Netflix docuseries titled Buried Truth, the Indrani Mukherjee story has been stalled till next week. As you are aware that a petition has been filed by CBI before the Bombay High Court seeking a stay on the documentary's release. Today, a single bench of Justice Revati Moite Dere heard the matter. The bench asked the makers to hold a special screening for the CBI. The court reasoned that since Indrani Mukherjee is a prime accused in the Sheena Bora murder case and the documentary depicts her version of the case, it is relevant for CBI to view the documentary. Justice Dere opined that when the trial is ongoing, the question arises whether an accused has the right to release such content and if it is contravened any bail conditions in the same. When senior advocate Ravi Kadam and advocate Abhinav Chandrachud for Netflix said that allowing the agency to view the film or stalling its release would amount to pre-censorship, and that Indrani Mukherjee had already published a book which the CBI had not objected to, the court, after hearing ASG and advocate Shriram Shirsat appearing for CBI, allowed the special screening. They stated that the docuseries would influence witnesses and impact the ongoing trial, especially since the makers already admitted that 5 witnesses are interviewed in the docuseries. 3 of these have been examined, while 2 others are yet to be examined. And now let me brief you about an important hearing on whether services rendered by the lawyer would come within the Consumer Protection Act of 1986. The Supreme Court today inter alia deliberated on whether a consumer under the Act can be equated with the client. Additionally, the court delved into whether negligence on the part of a lawyer can result in deficiency of service as given under the Act. The matter was placed before Justices Bela M. Trivedi and Pankaj Mittal. Continuing with yesterday's submissions, Senior Advocate Guru Krishna Kumar, representing the Bar Council of India, endeavoured to persuade the bench by emphasizing the distinct nature of the legal profession when it comes to matters of legal culpability. He emphasized that the legal profession cannot be equated or compared to any other service provider in a trade or commercial sense. Krishna Kumar referred to several legal precedents to illustrate how the courts have dealt with professional misconduct earlier. Through these decisions, the senior counsel also intended to demonstrate the jurisdiction exercised by the Bar Council and Advocates Act in such cases. He clarified that the argument was not against the concept of liability. However, liability cannot be under the Consumer Protection Act and before the Consumer Forum. As you are aware, from past few days, farmers in large numbers have been protesting in demand of legal guarantee of minimum support price for all crops. In this regard, the police in Haryana, Punjab and Delhi have tightened security and sealed borders to maintain law and order. Unfortunately, there have been instances of tension, including encounters where tear gas was used by law enforcement. A journalist has moved the Punjab and Haryana High Court seeking registration of FIR against the officials of Haryana police who allegedly struck a tear gas shell that landed on his head while he was covering the farmers' protest within the Punjab government's jurisdiction. He has highlighted that thousands of journalists have been subjected to physical violence and gunshot wounds inflicted by the Haryana police authorities at the Shambhu border. Pertinently, another application has been filed by an advocate in the Punjab and Haryana High Court regarding a concerning incident at the Khanori border. It seeks a judicial inquiry conducted by a retired High Court judge into the alleged death of a 22-year-old youth, reportedly due to violent actions by the Haryana police or paramilitary forces. The plea also seeks issuance of directions to the centre and state to place on record the complete data of the tear gas shells, pellet guns and rubber real bullets used by the police, paramilitary forces, so as to enable the court to ascertain whether the force used by the police or the paramilitary forces on their own countrymen is reasonable or indiscriminate and inhuman. The matter is listed on 29 February for further consideration. In a significant development, the Manipur High Court has modified in part its order from 2023, whereby a contentious direction was issued to the state government for considering inclusion of Meiteis in the scheduled tribes list. The impugned direction was to the effect that the state shall consider the case of the petitioners for inclusion of the Meitei or Meitei community in the scheduled tribe list on an expeditious basis. If you remember, the ethnic conflict between the Meiteis and the tribal Kuki-Zo communities in the state erupted following this High Court direction. Well, now the High Court has withdrawn this direction. The bench of Justice Golmei Gaiful Shilu was hearing a review petition filed against Para 17(3) of the decision from March last year, rendered by Acting Chief Justice M.V. Muralidharan. The review petition was filed by petitioners from the Meitei community, who were the original writ petitioners themselves. They sought review on the ground that the direction was barred by the Constitution Bench judgment of the Supreme Court that a judicial direction cannot be issued for inclusion of a tribe in the ST list, as it is the sole prerogative of the President. And lastly, coming to an update from the Calcutta High Court, which today granted bail to a journalist from Republic TV who was arrested while reporting live from Sandeshkhali in West Bengal on 19th February. According to the reports, the state authorities had alleged that the journalist was arrested for outraging the modesty of a woman by entering her home while reporting. These charges were, however, denied by the journalist, who claimed that his arrest came since he was exposing the truth in Sandeshkhali. The bail was granted by a single bench of Justice Kaushik Chanda today. The situation in Sandeshkhali has been tense, especially after a team of Enforcement Directorate officers was attacked while en route to raid the home of local leader Shah Jahan Sheikh. The raid was part of an investigation into a large-scale ration scam involving millions of rupees. You already know that the High Court has initiated a suo motu action on reports of women being allegedly sexually assaulted at gunpoint by local political leaders, as well as tribal lands being grabbed by political strongmen. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.